Board of Tax Assessors to order. The agenda is pretty short. Does anyone have any modifications to the agenda? I would ask for a motion to adopt the
So
agenda.
moved. Second.
All in favor?
Aye.
House Bill 1383. That's the point of discussion today, and I hope it can be shorter and a little more casual and quiet than the last meeting we had on this subject. I have just provided the board and a couple of other people a number of documents which are really the public minutes of the sessions we've had over the last year. We began discussing this issue in July of 18, and in public meetings and in the paper we have had numerous discussions about the homestead audit. The BOA policy number 29, which really directed the tax assessor's office to conduct a review of the homestead for the exemptions for the school tax exemption, was passed in September of last year at a public meeting and reported in the paper. It goes on and on. March 21st, it was the audit was should be complete. April 18th, it was complete. And then in May, we had the minutes record that there were approximately 2,400 inserts that would be included in the assessment notices having to do with how the detached structures were handled in this 2019 tax year. And of course, I guess everybody here was in the meeting of a couple of weeks ago. Let's see if I can read how it was left. It says, upon motion of Gary Engel, seconded by Gerald Davis, to move forward with the current policy in place for the 2019 tax year with the appeal procedure in place. And that was the decision of the board. Now, we also said that we would ask for an opinion from legislative counsel. We have received such, and it's 3 pages, and anybody would like a copy of it, I'd be glad to furnish them a copy. But he summarizes his 3-page discussion by saying, I believe this question involves a determination that must be made on a case-by-case basis locally. And then goes on to express his opinion for and against the decision that had been made by the board. Now, today, we're in receipt of the correspondence from the legislative director of the ACCG, which is sort of counsel to the county governments of the state. And, he says, homestead includes the following qualifications: the actual permanent place of residence, and where the building is occupied primarily as a dwelling. And in other words, with respect to the home, the exemption is limited to that attached structure, so that attached structures are included, garage, deck, etc. Other structures, such as detached garage, gazebos, are not included. Detached structures, to my knowledge, have never been included as part of the building which is occupied as the primary dwelling, or at least they are not supposed to have been so included. So that's where we stand at the moment.
Who is this guy?
He is the counsel to the What's the ACCG
It's
stand for?
Association of County Commissioners of Georgia. It's the entity that represents all of the counties throughout the state. They're based in Atlanta, and it's the ones that are primarily turned to for questions with respect to county laws and things of that nature. He's their counsel down there, Joe Scherer.
Joe who?
Scherer, I probably have to spell it for you.
Here,
Scherer.
it's got everything is in there that we just said.
But ACCG is the organization upon which, like I said, they do everything for the counties throughout the state. That's who the county itself has got insurance through, as far as I believe even the medical is through them, if I'm not mistaken, is through ACCG. So I know the liability insurance, all of the insurance. They are typically the ones that put on seminars and things throughout the state. It's hard to explain, but it's kind of like the central clearinghouse for everything countywide.
Sorry to interrupt you there, Tom, but I didn't know who this guy was.
Oh, yeah, by all means.
But he is an attorney.
He's an attorney, but when I look at what he says, it varies and differs from what the state legislative liaison says.
Right.
And that's the thing and that's the reason, again, at the end of the day, I believe in an opinion from the Attorney General, who is the attorney that represents the state, is what really needs to be sought.
You know, I voted no on this thing last time. In the part that, on the thing that we got here from the Legislative Services Committee, and I'm at number 3 here. Based on the principles and case law discussed about it, I'll provide my thoughts as how a court might rule on the spectrum of scenarios. Regarding storage sheds, gazebos, at one end of the spectrum, I believe the court would be inclined to rule that such structures are incidental to the residential use of the property and would thus be included in the exemption. On the other end of the spectrum, I would think that a detached garage is used as a repair shop, second floor apartment for renting out, a shed for a wash repair business, or a mobile home would be excluded from an exemption. I think that's pretty clear. We've not had a challenge on it in 10 years. It's rocked along for 10 years fine. And I'm inclined to repeal what we've done and put it back as it was in 2018 until there's an issue. You've got two conflicting things right here, and I'm going with the one right here from the Legislative Services.
Well, I would add that what we've got is two dramatically different opinions in my estimation, and that we deserve a clarification from the Attorney General, and that's about as definitive and final as we're going to get.
You're not going to get that this year?
No,
No.
you would suspend the application. I would never encourage you to continue forward with it as it is at the previous or how y'all made the motion. You would suspend its implementation until you got that opinion.
I would make a motion that we repeal what we've done for this policy and go back to the 2018 policy until we get a further clarification. So that's my motion.
Okay. We need a second before discussion.
I'll second that.
Can I hear that again, please?
This policy 29, I'd make a motion to undo it and suspend it until we get a further clarification and not take effect for 2019.
So you're saying we go back to the previous year?
Previous year, 2018.
Now, I seconded it, but at the same time, I think that we probably could utilize some of the response that we got from the legislative folks to clarify some of this. The two exemptions that I see is if somebody's got a residential, the second residence on the property, or a commercial operation on the property. Those are the two exceptions to the exemption, if that makes sense. I think we probably and our approach to that need to consider clarification of that. And
Well, I
rather-
think 29 takes that into
Does
consideration.
it? And I don't know, I don't have it in front of me right now, so that's what I'm saying, that we need to clarify from that perspective, i.e. gazebos, pools, and those type of things. The lady was back the other day, had a little shed that she kept her mower in and stuff, and was concerned about. Those type of things, I think if we're gonna err, we need to err on the side of the taxpayer. And
I agree.
so that's kind of where I'm coming from, if that makes sense.
Any other comments? I would call for a vote.
Aye.
Aye. All right, I think we just suspended the changes in the taxes for 2019, and we'll seek a definitive response from the Attorney General's office.
Which at the last meeting, we stressed the ability to come back and do it at this time. Okay. Good.
Now, the question that I have is, based on what you just told me, it appears that that type of statement that's in there that he read a few minutes ago, the only two exceptions to what's on that property is a dwelling or a residential, a second dwelling, or a third dwelling, or residential or commercial property. Is that included in the way the verbiage previously was written?
That's correct, that's the previous 2018. He's talking about like chicken houses, business.
Business.
Business would be.
In other words, if I have a tasting room on my property, which I do, then
It's still excluded.
still it's unfortunately it's excluded, okay?
Yes,
So,
if we have it taxed as a commercial entity, then it would still be excluded, as long, and the second, third residences. What we will not be able to identify 100% would be maybe a prefab metal building that somebody's running a small business on until we do a field inspection and find a business is in there. And then, of course, poultry houses or anything like that now go back under the exemption.
but our code, our law, that we're operating under,
Local procedure.
breaks that out, is that correct?
Breaks out commercial.
So that when we're gone, we don't have the same discussion 10 years later with the next board that's dealing with this, right?
But based on what you guys just undid, it does include back in poultry houses and all unattached buildings, so.
Well, the purpose is suspending what we did. If that was excluded before, it should have been excluded in 2018.
Poultry houses were not excluded, they were exempted. So,
But that is we're saying that a poultry house is a business. Is that not right? Before a poultry house is a business operation that we give for CUVA because they're running a business.
well, they're
Chicken
running an
house,
agricultural
agricultural.
covenant, yeah.
So they're selling them chicken somewhere.
So, I mean, they're not identified on the commercial schedule. They're identified as an accessory improvement. So if we're bringing back all accessories, it brings them back too.
And last year,
They-
it brought them back,
It
and
did.
that's what we have voted on to do. Now, and like my recommendation before, and we can't do it now, we don't have enough time, but again, I would like to somehow come up with something with citizens involved, so that by the first of the year, we can have these items clearly identified.
Well, they're identified in our records.
Okay, okay, so then, we know those things then.
Yes.
Okay, so now give me an example of what, I mean, where, tell me where.
It's in the database for all the parcels.
It's
Okay,
in our schedules and tables, so.
Right.
it-
but, okay, that's something that, I can't go in and pull up right away. We need a list of that stuff.
That's what you shared with me, that I shared with legislative council, is what Jerry's looking for, I believe.
Right,
The
that's-
category. Yeah,
Right,
that category is pretty expansive. It probably, on an Excel spreadsheet, a printable sheet, probably 3 pages. So you'll see the dilemma that it presents to
Right.
the staff and trying to pick and choose amongst what would be an accessory, what would be detached, unattached, and all of this other stuff.
I mean,
So-
I understand that too, but I mean, that's what we're charged with. We have a responsibility to do that.
Yeah, and they
I mean,
have
if
been,
it-
they have been.
If it takes us 6 months to do it, then that's what we do. We don't shun from it.
Okay, I'm kind of, in 2018, the chicken houses were included in the 65 exemption.
That is correct.
See, I didn't know that. I didn't know they were in the, because I was under the impression,
I had the same impression, because I understood that back in '08, '09, and '10, we took all that out and took businesses out that had been swept up into the implementation.
If it's a commercial business, it's listed in the commercial schedules and tables. However, a poultry house is considered an accessory item, and it's valued in the accessory schedules and tables. Now, I can, if the board is giving that authority, I can, if I undo everything, I don't have to recheck them to include them in the exemption, but I need guidance from the board to know what you're asking me to exclude out. If I put everything like it was in 18, then that puts everything back in it.
Well, when I look at farms, across the board, chicken farm being no different than any other farm, I look at it and say, do we want to exclude them out? Because we want to exclude, apple processing or, I've got grapes, or somebody else is raising something for a profit, hopefully, on a farm. They just happen to be raising chickens. But do we then start saying, well, we got a cattle barn where the cows go in and feed, or we're storing hay, or it's used for the production of those cattle? Do we want to start down that path, or where do we draw the line is the question that keeps coming back at me, Jerry.
That's right. And but until we identify the whole thing, we don't know where to go.
I still get stuck on the part here about the business. If it's used as a business, regardless if it's rented, used, sold, and then on the very first paragraph here, it says, it involves a determination must be made on a case-by-case basis locally. So, and go back to Teresa about, I personally think that chicken houses are a business, because somebody's buying those chickens. So they're raising chickens. They're getting a CUVA exemption for agriculture for that. So, but to me, that's a double exemption.
What other items in your schedule would be involved in like chicken houses, business applications?
I mean, that would be the only, well, you could have a barn that has cattle that they're using to raise cattle in, but, I mean, we wouldn't necessarily be able to identify those the same because they don't have a unique characteristic. So we'd have to look at every single barn to see how the property.
We'd have to start all over again with audit.
Well, that's the same like a detached garage with a full in-law suite above it. We don't know. Unfinished bake, we don't know.
Yeah, with the detached garage, we have a label and we can identify the ones that have finished attic, but I can't tell you that that finished attic means that it has a kitchen, a bathroom. We can just tell you there's some type of heated space above it. And he uses very specific language saying that it's a small apartment. My appraisers won't know that from standing on the ground. We don't have that type of inside access. So I can tell you all the detached garages that have finished space above them, but I can't tell you that they're all
Okay,
a small
so,
apartment.
and now I'm asking, now, so in essence, if you had a detached garage that has an attic and you don't know if it's finished or unfinished, you can call it right off the bat finished.
Well, the appraiser typically has some type of knowledge either from the owner or from, being able to view it at some point. So
But
they
they're not gonna know kitchen or bathroom or anything like that.
typically not.
So
Unless the owner-
if you label everything as, okay, it has a kitchen, it has a bathroom, then it becomes the responsibility of the homeowner to come in and say, no, I don't have a kitchen and bathroom, and if you'd like to see it, then I'd be happy to show it to you.
Right, which is why we typically won't label it finished unless the appraiser has firsthand knowledge. We call it unfinished, so.
Tricia, I know we have an issue, a time limit issue here, like July 15th for this digest. I mean, I know that.
Yes.
So what is gonna be the easiest for the office here? Just to go just like we are, and put it was like 2018, and start this thing over in 2020.
Well, with all the stipulations that the deputy legislative council put in there, I mean, I don't think we can meet all those requirements,
can't.
period.
We can't do that without further guidance, because he creates whole new decision points.
Because he's also put a statement in here that says, say for a large tract, and he says that if there's a gazebo on, one end of the tract and the house on the other, then that means we're physically pulling up every parcel, locating the locations of these buildings, and what determines one end of the parcel versus the other end of the parcel. So doing what he's asking here is not something we could implement in a timely manner. I can, in a timely manner, undo what the board has suggested, and I can undo and go back to 18, as long as the board understands, unless you give me specific guidelines, some structures that you thought may not should be included will get pulled back in.
I think that's fine for this year, and maybe we can get a definitive answer for 2020. I think that's fine.
Yeah, absolutely.
I think that's probably gonna be easier on you anyway. And they're probably gonna get some of them caught up in it anyway.
We have very limited capabilities in the 10 days or so
Right.
left.
Well, that's fine. I know we're up against the wall on the time limit.
And we may decide that we leave it the way it is, because, which way do you go with it? Is it,
Well,
if you're a
especially-
farmer, even if it's a chicken farm, why is that treated different than a cattle house?
Especially
I'd like
what it
to see
says
all those.
Feeder lot or something,
I can-
And I know they might be a lot, but
Yeah, they're presented, they should be in part of the package when y'all approve the schedules and tables, but I know that's a pretty big
Yeah,
stack of
right.
paper, so I don't mind to isolate and send those to each of you guys, so.
I think that's the simplest thing to do, is go exactly like we were in 2018 and tackle the thing at the first of the year. If we get another opinion, then we can have a more definitive thing. I think that would be easier on me.
It would make things simpler.
And there's gonna be things gonna be caught up that
Exactly.
probably we shouldn't think of, but, I mean, we don't have enough time to sit down and figure it out.
But I think the point that Jerry made about having some discussions with some folks and figuring out what is it we want it to look like. Where do you draw the line?
it's good public relations. I mean, people can't go against it when they see their own. I mean, I know we're taxpayers too, but it's not like that. Can we go in, do we know of other tax assessors' offices that have already gone through this and made some kind of a determination themselves on what they call something?
Well, they go back to their local house bills, and most house bills are not this big. They have an acreage cap, an income
Dollar cap.
cap. They may say, the first 5 acres, and then that office may interpret it to say, okay, anything on the first 5 acres counts. So that's kind of where we're in a unique situation here because of the bill being so vague.
Yeah, man, you talked about 125 acres, and that's my case.
This one I was gonna bring up, he's talking about large tracts, which that was 125 acres we're talking about. I'm for leaving it like it 2018 and let her start over if we get something else in 2020.
Okay?
Well, we've already made that decision, so.
Yeah. Well, we have made the decision, but at the same time, you can't put unnecessary burdens and constraints on staff in 15 days, or less than 15 days. 10 days,
12 maybe.
12. That's all.
Sleep's overrated.
Okay. Teresa, do you have anything else?
No, sir.
I do not either. We Any comments from the public?
I have a
Yes, sir.
question.
Could I ask you to identify yourself?
I'm Dan Meadows, I was at the last meeting. And I don't know the answer, that's why I'm asking you guys. Do farms have to have a business permit of some sort? If you're an agricultural producer, you have a winery,
If you have a commercial operation, being that I know this, if you have a commercial operation, you have to have a business license and a number of other licenses as well.
Cattle
Taxpayer
farmers.
ID, all this kind of stuff.
cattle farmers, chicken farmers, same?
I don't know, I know farm winery, I'm a farm winery, I have to have all these licenses to operate a business there. If you're operating a business out of that and other than wholesaling the property, but that's what's happening with the chicken houses and stuff, is they're basically wholesaling, or they're raising the chickens for Pilgrims or whoever.
Under
on
contract,
right?
Okay, so they have a contract, so there's some paper trail that identifies them as a business producer.
I would think so, but I'm not in the chicken business, but
Well, if that exists, to me, there's your opening to call it a commercial enterprise and to tax it accordingly.
I agree with you, but when I look at a cattle farmer, he probably doesn't have a contract, but he does take his cattle over to the market and sell them. And he gets paid for that, so,
And the corn too.
right. And hay, so that's where you start
Okay,
getting.
I didn't know, I'm sorry.
Now, growing up on a farm, I mean, we raised a lot of hogs and cattle and corn and soybeans and all that kind of stuff. We sold that. We didn't have a contract with them, but every year we would sell that. So is that a commercial entity, or do you differentiate a farm being different, and then where do you draw the line?
So if you claim income on your tax return, you're a business, regardless of whether you have a license.
Not necessarily. You could claim it as a farm with a Schedule F on your income
On your
tax.
tax return.
On your tax return, that doesn't necessarily make you a commercial entity. It's a farm. It's classified different in the state.
Well, we've got some work to do.
So you see,
Yeah, but
Any other questions? Michael?
All right, these folks have already received an assessment notice for this year, correct? So what happens now in regards to that? Do y'all send new notices?
No.
How's that gonna play out?
The individuals that filed an appeal, if they had any discrepancies outside of the school tax, they'll receive either their corrective notice or Board of Equalization. This would be a mass change. So this would be a mass change to all 2,400 accounts, whether those individuals appealed or not. So they're gonna get the benefit on their tax bill of not seeing that. Because it's actually up to the tax commissioner to apply the exemption once the new millage
Right.
rates are established.
So even though their assessment notice has those buildings and everything, unattached structures set aside, eligible for taxation, they're gonna see it corrected on the tax commissioner's end, or?
With their bill, unless they filed an appeal, and then if they filed an
Right.
appeal, we'll send out a corrective notice. But we won't reissue brand new notices, because it's
Okay.
just an estimation, and it's still based on last year's millage
Right.
rate. So it's
Right.
incorrect from the beginning.
So they've got the rates and everything from 2018, and that's what's gonna be.
so
Not the mill.
they just get surprised when they get their tax bill, it'll be less than what
Right.
they were told.
So that's, okay,
Yeah.
I understand.
And I assume an article in the paper will help.
Well,
Of
I
those
didn't know how
individuals.
y'all were gonna go about that if you had to.
Yes, sir.
I have one question.
What, could you identify yourself?
My name is Keith Ruckert, and I live out off Big Creek Road. We've already had apparently 2 opinions from Legislative Council and this one recent one. Now we're asking for the Attorney General. So now you've got 3 opinions. They all may vary. How do you sit down and make a decision? You've got 5 people on this board. Which authority are you going to pick as being the final word? Is the attorney, I'd ask David this, is the Attorney General the bona fide last thing that can happen?
Generally speaking, with the interpretation of a statute, the Attorney General is responsible for guidance as far as the state is concerned. Now, ultimately, it may be a court, though, that ultimately makes that decision, but for purposes of an opinion, the Attorney General, that's generally their responsibility is the interpretation of statutes. And that's what's at play here is the definition of homestead under that statute.
Well, it just seems that we've gotten two opinions, maybe three, because the one person said, well, I think a judge would say that these were not exempt, et cetera. We're getting more people involved. Y'all are getting more people involved. I'm just a taxpayer. I don't know how you make it a cut and dry decision. It's gonna be very difficult on y'all.
But the Attorney General is the senior attorney for the state of Georgia. That, he trumps these other guys. So that's what he's saying.
Okay, I
that this
understand
guy's
that.
gonna trump these
Okay,
conflicting
so if
things.
he comes with a decision that's cut and dried, it's in front of you, you gotta go with it, right?
Yes.
We've got two different
Or
ones
we can
now,
pass a
and
new
we
law.
go back to
I mean-
the previous.
We
Or
can
couldn't
do,
the county make a new law?
yes, and put it on the ballot, we vote.
Well, that would require the legislature to do that.
It's a state law that we're, the state code that we're dealing with here.
Yeah.
So we can't change the state
Okay.
code.
And there's two pieces of it. There's a state code that I cannot conceive of legislature modifying that because of the decision,
Yes.
this discussion.
Yes.
Is Gilmer the only county that is faced with this problem?
No, but there's about 12 or so, and most of them have qualifications inside the legislation that we do not have.
Ours is much more nebulous.
It's undefined is really what it is.
Could be
It's everything. And
Well, how does that get corrected so that this doesn't come up again and again? And-
well, it would require a House bill approved by the Senate and voted on by the taxpayers, which is another reason that I don't think that's ever going to happen.
Okay, I understand that. I didn't mean to bring up a bad question, but it
No,
just
that's a
seems-
valid
It
question.
just seems like that we get this opinion and this opinion and this opinion. We've got 5 intelligent people, a county attorney, a tax assessor, and et cetera, that should be able to make a decision for the benefit and the welfare of the people of Gilmer County. That's what y'all are
Right, and
are
that's why
charged with doing.
that's why the Legislative Council starts his 3-page document off by saying it's a local decision.
And we just.
Paragraph
reversed
one.
that.
To make it simple.
I understand that you just reversed that, okay.
Okay, if there's nothing else, I would make a motion to adjourn the meeting. All in favor? Aye. Thank y'all very much.